We welcome Honorable Justice Chelameswar. Please come. We start the program with தமிழ் தாய் வாழ்த்து. தமிழ் தாய் வாழ்த்துடன் இந்த நிகழ்வு தொடங்குகிறது. அனைவரும் எழுந்து நிற்குமாறு பண்புடன் கேட்டுக்கொள்கிறோம்.
எத்தனவும் அது சிறந்த திராவிடர்கள் திருநாடும் தத்த சிறு திரை முதலும் தரித்தனவும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம்பியந்த செயல்மறந்த வாழ்த்ததுமே வாழ்த்ததுமே வாழ்த்ததுமே.
தேங்க்யூ. அனைவருக்கும் நன்றி. Let this program start with a welcome address by Dr. G. Sundar, the director, Roja Muthaya Research Library, and I invite Mr. Sundar to deliver the welcome address.
Very good morning to all of you. I warmly welcome all of you for this August event. We are gathered here to celebrate the 24th birth anniversary of Rakesh Ranganathan, son of Tirumati Aruna Ilango and Thiru N.R. Ilango. Rakesh was a cheerful and spirited young man, and we deeply miss him on this occasion. Rakesh Endowment Lecture Series for Justice and Equality was constituted in memory of him by the Rakesh Law Foundation at the Roja Muthaya Research Library. RMRL has been in existence since 1994, dedicating itself to documenting, preserving, and disseminating the civilizational knowledge of Tamils. It is now creating the Tamil Knowledge Campus with the support of philanthropists, corporates, and the government of Tamil Nadu. We are honored to associate with the Rakesh Law Foundation in organizing this lecture series. Dr. Raghavi will elaborate about the Rakesh Law Foundation. Today's lecture will be the fourth in this series. It is a great privilege and honor to have with us Honorable Mr. Justice Jasti Chelameswar, former judge of the Supreme Court of India, who will be delivering a talk on the 75-year journey of the Constitution of India. I extend a warm welcome to him and thank him sincerely for accepting our invitation. I extend a warm welcome to him also to Mr. Stalin Abhimanyu who will be introducing him shortly. I also take the pleasure in welcoming Honorable Mr. Justice G.M. Akbar Ali, former judge, Madras High Court, who will be moderating today's session. He served in various capacities in the judiciary. After retiring, he continued to contribute to justice through important arbitration roles. Justice Akbar Ali's dedication to legal education and public service remains an inspiration for many. I welcome Dr. Raghavi, daughter of N.R. Ilango, a medical doctor by training and vice chairman of Rakesh Law Foundation. She will elaborate on the vision and mission of RLF. I also welcome Mr. Stalin Abhimanyu and Dr. M. Ranjit, the treasurer and assistant treasurer of Rakesh Law Foundation, respectively. Dr. Ranjit will deliver the vote of thanks. On behalf of the Rakesh Law Foundation and the Roja Muthiah Research Library, I welcome all the judges, advocates, bureaucrats, politicians, and the members of press present here today. A warm welcome to all students who have joined us on this Saturday morning with great enthusiasm. Once again, a warm welcome to each and every one of you.
Thank you, Sundar, for your welcome address. Before we move on to other programs, first of all, I request Mr. Ilango to felicitate with our chief guest with a shawl. Rather, a பொன்னாடை. இந்த தமிழ் ஒன்றின் சிறப்பு கணங்க வந்திருக்கக்கூடிய சிறப்பு விருந்தினருக்கு ஒரு பொன்னாடை அணிவித்து மகிழ்கின்றோம். பரத்த கைப்பற்றுவோம். I request Raghavi to present a book. Open the book and give. The book is nothing but a journey of a civilization in an apt application of the journey of the Constitution. Thank you. Thank you. Before we move on to other items, I have, you know very well Rakesh. Everybody knows Rakesh, our beloved Rakesh. You touched our lives with your laughter and love. In our memories, your laughter echoes still. Though your time was short, your impact deep, a legacy to keep. Your dreams unfold every year this day. Your dreams unfold every year this day. We cherish your memories. In our hearts, your spirit will forever stay, a shining light that guides us on our way. Turning it into a memorable moment, yes, turning into a memorable moment every year, a lecture series for justice and equity. We'll hold on to the moments we shared with the glee, and we celebrate your memories, love for you for every scene. எங்கள் அன்பு மகனே ராகேஷ், உன் அன்பாலும் புன்னகையாலும் எங்கள் நினைவுகளை வென்றாய், உள்ளங்களை வென்றாய். எங்கள் நினைவுகளில் என்று உன் சிரிப்பின் எதிரொலி. உன் காலம் குறுகியதென்றாலும் அதன் தாக்கம் ஆழமானது, அது தக்க வைக்கும் ஒரு மரபு. உன் கனவுகள் வெளித்தலும் ஒவ்வொரு ஆண்டும் இந்நாளில் உன் நினைவாலே எங்கள் காலம் செல்லும். எங்கள் இதயங்களில் நேர்ந்திருக்கும் உன் புத்துணர்ச்சி என்றென்று ஒளியாக வழிகாட்டும். அதன் நினைவாலே ஒவ்வொரு ஆண்டும் ஒரு சொற்பொழிவு, நீதியும் நியாயமும் கேட்டு நாம் மகிழ்ந்திருந்த பொழுதுகளின் இனிமை வழுவா நினைவுகள் கொண்டாடுகின்றோம். உன் நினைவுகளை என்றென்றும் அன்போடும் பாசத்தோடும். Let us celebrate the birthday of our beloved Rakesh. I request your lordships to offer and celebrate our birthday of our Rakesh. Thank you. As you know, every day, every year, the Rakesh Law Foundation and Roja Muthiah Research Library celebrate the birthday as a lecture series for social justice and equity. And today's lecture will be delivered by Honorable Jasti Chelameswar, the 75th year journey of the Constitution of India. Before we go into that, I request Raghavi to spell out the mission and vision of the Rakesh Law Foundation, please.
Good morning to all. It's my privilege to address you all today as we reflect on our foundation's missions, accomplishments, and vision moving forward. I begin by expressing my heartfelt gratitude to the members of our foundation, Mrs. Aruna Ilango, the chairman, Mr. Gandhi Balasubramaniam, the secretary, joint secretaries, Mr. Ashwin Prasanna, Mr. Agilesh Kumar, treasurer, Mr. Stalin Abhimanyu, and assistant treasurer, Dr. Ranjit Mari. I'm equally in debt to our distinguished advisors and extended family who continue to be guiding lights for our foundation. I would like to thank Honorable Justice Raj Elango, Honorable Justice C.T. Selvam, Honorable Justice Akbar Ali, Mr. Serin, and Napinay Aunty, Mr. Sundar of Roja Muthiah Memorial Library, advocates Mr. K.S. Ravichandran, K.J. Saravanan, and Mr. Pachepan, and all the members of the DMK legal wing. And also I would like to thank the beloved juniors of Daddy who have consistently supported our endeavors. To start with eliciting our journey, the milestones of excellence, prestigious lecture series, we started on April 2022, the inauguration of the Rakesh Law Foundation, which was graced by the Honorable Chief Minister of Tamil Nadu, Mr. M.K. Stalin, and Honorable Deputy Chief Minister, Mr. Udayanidhi Stalin. We were privileged to have Mr. Kapil Sibal deliver our inaugural lecture on the thought-provoking topic, Is the Democracy Envisaged by the Framers of the Constitution, which was masterfully moderated by Mr. N. Ram of the Hindu. Following by which, April 16, 2023, we continued our commitment to intellectual discourse with our lecture series on Pillars of Indian Democracy, featuring the distinguished Dr. Abhishek Manu Singhvi, and was moderated by R. Sasikumar, Director of the Asian School of Business. Following by which, April 30th, 2023, a lecture series addressed critical legal perspectives with a session on guilty till proven innocent, the dark areas of the criminal jurisprudence, given by Justice Dr. Muralidharan and was moderated by Justice Akbar Ali. So the missions are impact, creating lasting change in the educational infrastructure development. In the year 2022 September, marking a significant milestone, we established a memorandum of understanding with the Chennai Corporation to adopt the Chennai Higher Secondary School in Subrayan Nagar, Aminjikarai. Our contributions have included donation of rupees 2.5 lakhs and installation of an RO plant, installation of new blackboards, donation of essential books for the students, setting up modern projection equipments, funding specialized need coaching by appointed dedicated teachers. The additional educational initiatives which we've done as a foundation, donation of students' desks to CSI Matriculation School in Sholingar, collaboration with the EduRight Foundation to conduct graduation ceremonies for students of grade 9 to 12, recognizing the excellence in English. Establishment of the Rakesh Ranganathan Memorial Certificate Program to honor academic excellence among students, securing top 3 ranks in the school level examinations. Knowledge disseminations beyond classroom, inauguration of a specialized library session at the Madurai bench of the Madras High Court, organization of lectures on new evidence acts with the emphasis on electronical evidences by Honorable Justice Mr. N. Ananda Venkatesh at the Madras High Court, development of playground facilities at Goodlett High School Secondary, Sholingar, where my father studied. We also supported the public education, taking an exception to funding delays from the central government. The Rakesh Law Foundation proudly donated rupees 10 lakhs to the Namma Oor Namma Palli scheme, requesting the Honorable Chief Minister of Tamil Nadu to direct these funds towards developing government schools in Ranipet district. Recognizing the excellence of our foundation remains committed To recognizing and nurturing talent, the Rakesh Ranganathan Memorial Certificate Program continues to honor consistent academic achievements, which will happen shortly today. Moving forward, the vision of our foundation, the Rakesh Law Foundation wants to reaffirm its commitment to advancing legal education and discourse through our distinguished lecture series, strengthening educational infrastructure in the underdeserved communities, recognizing and nurturing academic excellence among the young learners, serving as a bridge between the legal luminaries and the aspiring professionals, upholding the legacy of our inspiration and my dearest brother Rakesh Ranganathan. So, in conclusion, I express my profound gratitude to all of you who contributed to our journey. Together, we want to continue and build the foundation's mission of educational empowerment, legal excellence, and community service. I thank you all.
Thank you, Raghavi, for elaborating all those good things we have been doing under Rakesh Law Foundation. Now it is time to introduce the speaker. I know everybody will say that there is no necessity to introduce our main speaker, His Lordship Justice Chelameswar, known for the uprightness and the boldness. And you remember that all those interviews that have been held. Anyhow, we have to introduce our speaker. I request Stalin to come and introduce the speaker.
Esteemed dignitaries on the stage and off the stage, my dear brothers and sisters, I wish a very warm good morning to you all on behalf of the Rakesh Law Foundation, established with fond memories of our beloved Rakesh. On this poignant occasion, I have shouldered the responsibility of introducing the speaker. A great man is known. He needs no introduction. That is what our distinguished chief guest, Honorable Mr. Justice Jasti Chelameswar, an eminent former judge of the Honorable Supreme Court of India, celebrated for his sharp legal mind and fearless candor. Born on 23rd June 1953 in Pedumatti village, Mova Mandal, Krishna district, Andhra Pradesh, he is the proud son of Mr. Jasti Lakshmi Narayanan and a lawyer at the district court, and Mrs. Annapurnamma. After completing his schooling in Machilipattinam, Justice Chelameswar's educational journey began with bachelor's degree in physics from our Madras Loyola College, followed by a Bachelor of Law from Andhra University, Visakhapatnam, 1976. Soon after, he began his career by enrolling as an advocate at the High Court of Andhra Pradesh, practicing under renowned senior advocates Dr. B. Bhimraju, Mr. P. Raja Rao, and Mr. K. Srinivasamurthy, further sharpening his legal acumen. Justice Chelameswar's commitment to public service led him to hold different posts, important posts, including standing counsel for the Andhra Pradesh of Lokayukta in 1985 and 1986. He also served as a government pleader at the High Court of Andhra Pradesh from 1988 to 1989. His legal expertise was further recognized in 1995 when he was designated as a senior advocate and appointed as an additional advocate general for the state of Andhra Pradesh. After extensive practice in various parts of the country, Justice Chelameswar was elevated as an additional judge of the Andhra Pradesh High Court. After 2 years, Justice Chelameswar was appointed as a permanent judge of the Andhra Pradesh High Court in May 1999. 8 years after serving at his parent High Court, Justice Chelameswar was elevated as the High Court Chief Justice of Guwahati in May 2007. From Guwahati, he was transferred to take charge as Chief Justice of Kerala High Court in March 2010. He was elevated as a judge of the Honorable Supreme Court on October 10, 2011. Our renowned chief guest had once remarked, "There are small ways of doing big things, and there are big ways of doing small things." He has exemplified these very words time and again through his bold judgments, either in concurrence or dissent. His notable judgments in declaring Section 66A of the Information Technology Act as unconstitutional, his contribution to the Haryana Panchayat Raj Amendment Act in introduction of minimum educational qualification for candidates for contesting panchayat elections, his notable contribution in Aadhaar case are just some of the twinkling stars of the legal universe. Mr. Justice Chelameswar is notable dissenter in the glorious history of post-independence judiciary. Justice Khanna is remembered for his brave dissent in ADM Jabalpur case. His remarks on dissent have personified dissent as an instrument of vibrant democracy and robust judiciary. To quote Justice Khanna, a dissent in a court of last resort is an appeal to the brooding spirit of law, to the intelligence of a future day, when a later decision may possibly correct the error into which the dissenting judges believe the court to have been betrayed. Justice Chelameswar was bearing the torch of dissent with conviction and courage during his long checkered career as a judge, and notably during his tenure in the Honorable Supreme Court for 7 years. Justice Chelameswar's notable dissents in Office for Profit case and NGAC case would wait for its day to correct the error. Transparency and accountability issues were close to him, and he spoke consistently and unequivocally through his judgments. He was an ardent critic of the collegium in its current form. Living up to his views, he opted out of the collegium, though he was the second senior most judge of the Honorable Supreme Court. Justice Chelameswar retired as the judge of the Honorable Supreme Court on 22nd June 2018, but his concern for transparency and accountability still reverberates across the country, especially in the aftermath of the fire accident in the posh Tukla Crescent area of Lutyens, Delhi on the 14th March 2025. It can be safely said that Justice Chelameswar represents a rare breed who walked the talk and who walks every high amidst us to keep the institution of democracy and judiciary vibrant and robust, in tune with his concern to sustain the faith of the general public in this country in his own small ways of doing big things. With great admiration and respect, I present to you all His Lordship Mr. Justice Jasti Chelameswar.
Thank you, Stalin, for an elaborate introduction about our honorable chief guest. And before we move on to that, our Mr. Elango wants to say something about the chief guest. Please come.
Though what I say, what I want to speak is not there in the agenda, I want to tell a few words about Justice Chelameswar. There is a very famous case reported in 2015 7 SEC page 497. That's a case reported in R. Dinesh Kumar alias Dina. That case went from Madras High Court, where I argued the matter with reference to section 132 of the Evidence Act. A person who examines himself as a witness, if found to be an accused involved in a conspiracy, whether he can be added under section 319 or not was the question, moot question. The Madras High Court division bench dismissed it, and it went up to Supreme Court. I had the benefit of appearing before His Lordship along with Mr. Sharan. The judgment of the Madras High Court was reversed, but our prayer was dismissed on some other ground. The ground was, I was very confident that we will win the case because we were relying upon a case of 1881 Madras, where 4 judges of the Madras High Court held in my favor in that point. And His Lordship Justice Mutswami Iyer had a dissent view. Yes. 3:2. I'm sorry. The dissent view of Mutswami Iyer was upheld by His Lordship Justice Chelameswar. There is a connection between that case and Rojamuthiya Library as well. Friends, I'm telling you, ILR 1881 Madras, that book was not available anywhere, including Supreme Court Library. So I was searching, I requested Mr. Sundar to help me out. That book was traced and a copy was taken by Mr. Sundar from one of the digital libraries in US. US Digital Library is having all the ILR volumes of Madras. So he is having a role to play in this case. Rojamuthiya. What I wanted to tell is, yesterday when I received Justice Chelameswar, I was telling him that this case I argued here, and he said, and I told him also that though we failed in our petition, your lordships have held the law correctly. He said, the role of a judge is to close his eyes on the parties, and the role is only to propound the law. That is what India needs, and that is what Justice Chelameswar is. We thank him for that view, and I request Justice to speak.
One second. I was also thinking about that. Many of our honorable judges would have been. Why always dissenting? But I want to dissent with you, Stalin. I want to dissent with Vilango, because it's not always the dissenting. When it comes to anything like in 12th January 2018, I know that you would not have forgotten the day. 12th January 2018, your lordship was out there with the press conference saying what our lordships want to say about it. That is the transparency and the boldness. That is the transparency and boldness. His lordship also used to have interaction with, we would have watched in many TV series and everything. His lordship is the first honorable judge of the Supreme Court to go to the TV and public, say whatever questions put and whatever the answers that comes from your mind. And one of the question was, in the overall democratic, does that sound about right? They're asking about you have a very strong preference for a strict adherence of the separation of powers, and you are only willing to trade that off to increase the accountability. That was a question put to his lordship, and his lordship's answer was yes. If that is how you are or anybody understand my judgment, I'll be more happy in that. The transparency, the accountability. That was his lordship's thing. And we are here to hear from lordship the 75 years of the journey of our constitution, because 75 years have we achieved. That's what we are going to hear from your lordship. And the students, your opportunity, have an opportunity, lordship. This lecture series will be, your lordship will be telling them whatever lordship about the journey of the constitution. And we encourage the students and the advocates over here, all the luminaries are here to interact with your lordship so that we will be benefited. Thank you, lordship. I will welcome your lordship to deliver this. Please, lordship.
எல்லோருக்கும் வணக்கம். I really wish I could make a full-length speech in Tamil, but I'm a little worried. I can manage a conversation, but not a speech. In fact, when the meeting commenced, when the prayer was recited, in fact, I have saved this prayer on my phone. Whenever I listen to this, I get excited. I'm not trying to please anybody here nor flatter anybody here. In fact, I was asking Ms. Ravangovan's daughter, can you translate it into English for me? Because I told you, I can manage a dining table conversation, but I can't understand that level of Tamil, which is part of the prayer. She said, my father will be better than me. She said, anyway, then I'll request your father, I told her. Point is, my association with Tamil Nadu and this city is very long, for the last 3 generations. My maternal grandfather was a student of Madras Pachapas College. My father was a student of Pachapas. I went to the Loyola College. I have a long association with Tamil Nadu and this city as well. It has always been a matter of great pleasure to be here. When this invitation came, apart from the fact it comes from an advocate friend, an invitation from Madras I never declined in my life, whatever be the occasion. I'm sorry for using the word Madras because by the time I left this city, it was still Madras. It became Chennai thereafter. An old name revived. But then by habit, I always call it Madras. No, nothing else, no offense meant in that. There's more than one connection with Tamil Nadu. I was born in Tamil Nadu in the sense, by the date of my birth, the present Andhra Pradesh was still part of the old Madras province. I was born in 53 June. 53 November, Andhra state was carved out. So technically I was born in Tamil Nadu. I hope I'm audible. Is it audible clearly? Yeah. Oh, okay. Now, before I commence the, whatever you call it, speech or lecture, whatever it is, at the outset, I pay my tributes to the departed soul of Mr. Rajesh. It's unfortunate that a young law student had to leave this world in tragic circumstances. But the family, to perpetuate the memory of their beloved son, created this trust. And apart from organizing an annual memorial lecture, I'm told that they're contributing to the education of young children. In fact, it's a very noble decision the family has taken. And I'm grateful to the members of the foundation for inviting me on this occasion to be a part of the foundation. Thank you. Thank you, Mr. Langon. Coming to the topic, in fact, when I was invited, Ms. Irangovan was very considerate. He said, so we leave the choice to you, choice of the topic. Well, of course, the whole range is available. I said, okay, I'll talk about the working of the Constitution for the last 75 years. Now, I understand there are students of law here, advocate friends here, judges sitting in past, maybe the general public, some of them who do not strictly belong to the fraternity of law. The speaker on such an occasion will have a little difficulty because to communicate something at the same level to a lawyer and a law student and a non-lawyer is not an easy job. A lot of technical jargon would be involved in any legal communication. And if any speaker resorts to using the technical jargon, non-lawyer or people who are not strictly connected with law as a discipline of study might find it difficult. Therefore, I would like to avoid that. So my friends at the bar will forgive me if I sound a little too elementary in my approach to the subject. It's essentially meant for the younger generation. And if there is anything worthwhile in the words which are going to follow in the view of the lawyer friends, I'll be grateful to them for accepting it. Now, there have been celebrations for quite some time, about a year and a half now, at various levels. Delhi to, in the Hyderabadi lingo, they say Delhi to Gully. Gully means a narrow lane. All over the country, people have been celebrating 75 years of the Constitution. What exactly are we celebrating is the question. It's one of those rituals, or is there anything more than that? Before we go into that, let us have for the benefit of the youngsters, this Constitution of ours was not written on a clean slate. To borrow an expression from late Justice Krishna Iyer, not on a tabula rasa, a clean slate. There was a background. For me and generations after me, most barring a few faces, I don't find anybody older than me in this gathering. What, Mr. Purali, is there anybody in the gathering? I doubt very much, more or less. Anyway, for most of us, if not all of us, we are born in the Republic of India under the Constitution. Before this, for a couple of hundreds of years, we were under foreign rule. For at least 100 years approximately, from 1860 onwards, this country, and my dear young friends, I'm sure as students of law by now, if you have covered the legal history, what we call India today was not completely under the control of the British government. Only 2/3 of present territory of India was British India. 1/3 was still under the control of various local rulers like the Nizam of Hyderabad, the Raja of Mysore, Travancore, Cochin, so on and so forth. 1/3 of the territory was not part of British India. For the 2/3 of the territory which we call today India, the British had established a system of governance. From time to time, I don't want to trouble you with all the history. For the present day's purpose, in the process of the evolution of the system, legal system, governance, the Government of India Act 1935 is relevant in the context of what we are talking about, 75 years of the Constitution. The present Constitution of India, it's approximately some 70% of the document is more or less a copy of the Government of India Act. There's about some exact 30, 25, I never calculated approximately. Most of it is a reproduction of the Government of India Act. There are additions, there are a few deletions, that's a different matter. Now, what is it that the Constitution has given us in this country, in the Republic of India? The broad administrative system, based on a theory that concentration of power in the hands of either an individual or a single institution is detrimental to the liberty of the people. This was the theory on the basis of which all constitutional governance is envisioned. Nowadays, we hear a lot of talk about getting rid of the colonial past and colonial legacy. I always smile when I hear these words because it's more of rhetoric. This constitutional system itself is a colonial legacy. Before the colonial rule and the colonial legacy, we were ruled by small rajas, some 500, 600 rajas of this country. Each one was a constitution to himself. There was no division of power, absolute despotic monarchs. Some of them may be a little liberal, some of them little wise. That's not the point. But a representative form of government was not there. It is the colonial legacy which gave us this. Not that everything which is colonial is bad. You must always try to take even the great Indian poet Kalidasa says, whatever is in the past is not all good. Whatever is new is not always bad. The wise take the best of both the things. That is the spirit in which, if we have to have a healthy system, that's the spirit in which we must look at these things. There's no point in this rhetoric, colonial, discard it, do this, do that. That's all nothing. Now, how was it that the governance systems, we know the power of the state, ultimately what is the requirement of a state to maintain an orderly society? A society where people can live with dignity, at peace, without any fear of unwarranted interference from the fellow members of the society or outsiders, people beyond the society. This is the purpose of state. And in the process of providing such a system of governance to ensure an orderly society, this system of constitutional governance, detached from the whims and fancies of individual rulers, was developed philosophically. Essentially, the model which we follow, which we borrow from the Western Hemisphere of the world. There were theories which were propounded, accepted, they became default beliefs today. Nobody goes into this question. Why should there be a division of power between the various wings of the state? All of us know as students of law or lawyers that the power of the state is divided between three great branches of the government: the legislative branch, the executive branch, and the judicial branch. Why should it be divided is the first question. The fundamental belief is, over a period of centuries, in the last 3-4 centuries, that the distribution of power in between the three branches is better for the liberties of the people, because all of us see the glory in the executive branch. I think barring saints, most of us would perhaps love to be the chief ministers or prime ministers, because it's a very authoritative position. Well, please tell me if there is anybody who doesn't love to become the chief minister or prime minister of this country. Well, I'll salute him. Maybe he's a saint. The point is, because it's a glorious position. We see when people in office, big offices, chief ministers and prime ministers go, the kind of entourage that follows, the kind of adulation that the society heaps on them. Well, human nature is such, we would also like to enjoy and bask in that kind of a glory. But unfortunately, that glory comes with certain problems. In fact, the very famous statement of Edward Gibbon, a man who wrote that famous book called The Decline and Fall of the Roman Empire. Somewhere in the book he says, so long as mankind bestows greater applause on its destroyers than on their benefactors, the quest for military glory should always be the preoccupation of all exalted souls, it says. When we go to the streets, who are the greatest benefactors to mankind as a class? Forget about Tamil Nadu, Telugu, Tamil, India, Pakistan, all those things. Who are the greatest benefactors who have conferred greatest benefits to society? The scientists, Thomas Alva Edison, Alexander Graham Bell, so on and so forth, innumerable people, Madame Curie, innumerable. Did we anywhere find the statue of any one of these people? We don't find. We find the statues of Alexander, Aurangzeb, Ashoka, Harsha, well mentioned. But who are all these people? Without meaning any personal disrespect to any one of these people, according to the modern Telugu poets history, each one of them was a butcher. They killed lakhs and lakhs of people. Well, in the name of something, in the name of protecting this, in the name of protecting that, in the name of protecting their own people. The net result, but you find we deify these people, we worship them, we glorify them. So long as mankind continues to do this, every one of us would like to occupy that place, be the ruler, enjoy that glory. Now, but at least the thinkers realized this kind of a glory and power concentrated in a single individual would not, in the normal course, be beneficial for the liberties of the people. Therefore, cut it down, reduce it, distribute it. The ruler must be answerable to somebody. Who is that somebody? The primary answerability in a representative form of government is to the legislative body. Notwithstanding all the glory we see in the great public offices of ministers at state level, central level, and the black cat commandos and so on. What is it constitutionally they are doing? All of you youngsters, what is it that these people are supposed to be doing? They are there simply to implement the law made by the legislative body, legislative assembly or parliament. They don't even implement, they only advise the chief executive, the governor. And then, the power is delegated further up to the Tahsildar level or whatever is the last office in the state. Maybe in Andhra Pradesh, they're called the Mandal Development Office. I don't know where the whole Tahsildar system is still continuing in Tamil Nadu. Yeah. Okay. Or the local sub-inspector in the police station. But the fact that they have the authority, the executive branch has the authority to get the law implemented, confers it with a great degree of glamour, authority. And naturally, people crave for it. And there is always a possibility of power being misused. This is a proven fact in human history for millennia. Wherever there is the concentration of power had always been misused. Therefore, the theory was developed that power must be distributed among various organs. Three great branches of state machinery have come into existence. This is the background in which constitutional governing systems have been put in place. Before we attained independence and we became a republic, broadly the same system of governance was in existence in this country. What we call today the IAS and IPS officers were primarily the officers responsible for implementing the law in this country. There's nothing new under the Indian Constitution. It was in a different name. It used to be Indian Civil Service, ICS. The same system continues. The Constitution didn't really change it. We simply adopted it. Whether they should have adopted it or not is a different question. This is not the occasion for me to go into that. I'm not here to discuss a constitutional review committee. We're only taking facts as they are. They continue. The legal system which we have today, barring the Supreme Court, the legal system which we have today in this country existed for 90 years before the Constitution came into force, from 1860 onwards. There was nothing new in it. And so on and so forth. The only additions made in the Constitution is the distribution of powers between the union and the state governments. By the way, the division of the country, British India, into the old expression which all of us still use as central government, though the word central doesn't appear in the Constitution. Central government and the states today, what we call, or the provinces in those days. The old Madras province, Bombay, Calcutta, so on and so forth, various provinces. Power was distributed among these people for administrative convenience. The system has not changed, except that there was a reorganization of the territory. The number of states increased, and for various reasons, that's a different matter. But it's part of the distribution of power system. The only substantial change that is brought about by the Indian Constitution is the introduction of a chapter of fundamental rights, of guaranteed rights contained in Part 3 of the Constitution. Under the British government and the colonial rule, under the government of India, there is no such provision. Now, when India became a republic, the framers of the Constitution believed that people must have these basic rights, inviolable rights, irrespective of whatever are their elected majority. Because in a system of governance, we hear very frequently, almost every day for the last 75 years, at least ever since I started understanding the world and the world of law and started new. There have always been claims, we are the elected representatives. Sorry, Mr. Ilangovan. We are the elected representatives of the people. Therefore, we are elected by the people. We got the majority. So we can do no wrong. Whatever we say is right, and the Constitution has nothing to control us. This kind of a talk I have heard at least for the last 55 years, because before that I was a child. I didn't know. But I've been continuously hearing it by different people in different languages and in different contexts. This is exactly what the Constitution doesn't want to happen. There are certain core values which can't vary with electoral majorities. Whoever has the majority, whatever be the name of the political party, whatever be their political philosophy, whatever be the majority, whether it is a road roller majority or a slender majority or a coalition government, there are certain essential values, political values, human values, which can't be violated. The idea of incorporating a chapter on fundamental rights is that the right to free speech. Now, how much of it is being obeyed is a different thing. We'll come to it later. How the Constitution worked for the last 75 years, we'll come to it later. This is the purpose of the making of the Constitution, and particularly, otherwise, remove that fundamental rights chapter, I don't find there's anything much different between the Constitution of India and the Government of India Act 1935. This constitutes the soul of the Constitution of India. Now, it also presupposes ultimately governance in accordance with Constitution is not only following the letter of the law, but it's a constitutional culture. Culture has certain ingredients, and forget about the constitutional law and other things. when we talk about Indian culture or our Tamil Nadu's culture, we have certain practices, they are not written anywhere. There are certain things which are by tradition for generations, thousands of years, believed to be right and good in the context of the social system. Similarly, in implementing a constitutional system and governance, it is not always the letter of the law. I'll just give you one example. All of you would have noticed that judgment of Puttaswamy, Justice Puttaswamy judgment. The question there, for the benefit of this one, I'm sure lawyers would have gone through that judgment. If some of my young friends have not gone through the judgment of Puttaswamy, the question is whether there is a fundamental right of privacy under the Indian Constitution. The state very vehemently argued that under the Constitution there is no fundamental right of privacy, because in the text of the Constitution you don't find the word the right of privacy. Therefore, it's not there is the argument. Eventually, the matter went before a larger bench of 9 judges, of which I was also a member. And the bench unanimously held there is a fundamental right of privacy. See, the reason is this, but of course, the judgment is there, you can read it, and there are different opinions given. Conclusion is the same. Everything is not said in the Constitution. There are certain things which follow by necessary implication from the text of the Constitution. The silences of the Constitution, one very, very fundamental example, even before the right of privacy question arose, right from 1950 in this country, courts have repeatedly held, society has accepted it, that there is a freedom of press in this country. This expression freedom of press is nowhere in the document, constitutional document. You read the text of the Constitution, freedom of press is not there. It was by an interpretative process the judiciary has found this right as an integral part of the freedom of speech. That is the source of the freedom of press. Independent. Similarly, not everything is incorporated verbally or textually into the constitutional document. No, this is only one example which I gave. So therefore, there are a lot of these implications. This constitutes the culture of the Constitution. How do we understand? If I may be pardoned, may not be understood as boasting about my own judgment, only to just drive home the logic I'm mentioning. In the privacy judgment I mentioned, don't read this Constitution as a document written on paper with ink. You read it as a document written in the blood of the martyrs of Jallianwala Bagh. You will understand the purpose of this Constitution. Just don't read the paper, and it is not like any one of those legal documents which we write contracts between the parties or some promissory note dispute. It's not a document like that. It's something more profound. So every word, every concept incorporated in the Constitution must be understood with that understanding that is meant to endure for a long time, if possible for eternity. There's nothing eternal in this universe scientifically. Everything would disappear. But if we want to live in a dignified society, if we want our children to live a dignified life in this country, if we want the next generations to have it, if we don't want to be interrupted by a policeman on the way at his will. In fact, occasionally you find, some time back I received a message on WhatsApp. Somewhere in Madhya Pradesh, somebody was walking on the road, policeman caught him and saying, "Why are you not wearing a helmet?" This kind of, anything can happen. Why should a man walk? Well, tomorrow if the parliament or the legislative assembly is pleased to make a law that even pedestrians are required to wear a helmet, that's a different thing. There is a law. Whether the law is constitutional or not is a different question. But so far there is no such law. Pedestrians need not wear a helmet. Only the drivers of two-wheelers are required. I understand some other jurisdictions, some other countries, even four-wheeler drivers are also required to wear helmets. Anyway, we have not yet come there. But pedestrians is such a, but then we know what all happens. That is the problem with power. Policeman, a small salaried employee, has power. Just imagine how much worse it would be as the power grows more and more in the hands of people who lack this constitutional culture in them to regulate those people. In fact, when the American Constitution was being prepared, there was a lot of debate that went on. Three prominent men in public life those days published a series of articles expressing their views how the American Constitution ought to be in those days. And those papers eventually were collected and published in the form of a book. I don't know if some of you must have seen, book titled Federalist. I don't know if some of you have seen that book. In the paper 9 of Federalist, Hamilton, I think, 72, my memory is slowly receding. It says, if men were to be angels, it was a male chauvinist world by then. Men always included women. Forgive me, my dear ladies here. The statement is, if men were to be angels, no law is required to, no government is required to rule them. Because men are not angels. Just relax the power, all of us are capable of doing some wrong things, mischief. Some problem is always there. Such is human nature, we can't help it. That's how the creation is. So therefore a law is required. The next statement is, if angels were to rule men, no law would be required to guide them. The author of that article recognized rulers are also not angels, so therefore better structure their authority, create some discipline. This is the purpose which it forms a foundational principle of constitutional governance. Even those who are interested with this, ultimately, all the MPs, MLAs, they are only our representatives. Each one of them, maybe every MP, we have 1 lakh or 5 lakh, 1 by 10 lakh share in your MP, because all our votes constitute make him an MP or MLA as the case may be. He is just a representative. So therefore, please remind them always. No, I may not be understood as saying something against people in politics. I'm only trying to drive home the logic. This is true with any public office, including the judicial offices, judges at any level. Because before I was called upon to speak, some mention was made about my background. It was not just for fun I did all those things. I honestly believed that as judges, as holders of public offices, we are as much responsible as any other public office. We want, in fact, I said it on more than one occasion, we want the Prime Minister to answer the questions in the Parliament. And we want a country where any individual, yes, rightly, that small man with small pencil who is going to vote, has a right to ask the mightiest Prime Minister, why did you do this? You want the Prime Minister to be answerable. You want the Chief Minister to be answerable. You want the MLA to be answerable. You want the MP to be answerable. But to say that judges are not answerable to anybody, well, this is not consistent with the constitutional system. You are holding a public office, you are as much now, the parameters may vary, the procedures may vary in raising these questions. That's a different matter. But anybody holding a public office in a republic under the constitution is answerable to the people for the only thing is, judicial officers by default say a lot of decisions are taken by the government. A lot of laws are made by the legislative bodies, assemblies, or parliament. Debates go on there. They discuss. Sometimes they don't even discuss. Simply the bill is passed by show of hands. But nonetheless, in the system, once the majority of the members of the legislative body approve the bill, it becomes law and we are all governed by it. They don't have to give reasons. The legislature never gives reasons. They debate the reasons, but then there are individual opinions of the members in the legislative body. The only default condition for judiciary is that for every order you pass, you give reasons. Reasons, not fanciful reasons, reasons which have some basis in jurisprudence, some settled principles of law. You must be able to sustain your judgment or support your judgment with reason. That's one reason which marks out the judiciary. Therefore, they are conferred with a little more of protection. I'll tell you something. All my lawyer friends know. Judges know it much better. Law students must know it at this stage. I'm sure some of you will become lawyers, judges, some of you might become ministers also. We don't know what is in store for you. But for those of you who are going to become judges at a future date, please remember this. Every case you decide, you make one enemy because there are two parties. Well, this is a fact. Both the parties can't win the case. Only one party can win. The losing party will always have a grievance against the judge. If the losing party is a gentleman or a fine lady, the worst comment such a person can make is, this judge is an idiot, he didn't understand my case. If the losing party is not such a refined person, sky is the limit, anything can be said about it. The judge is corrupt, the judge is this, so-and-so spoke to him, Prime Minister spoke, Chief Minister spoke, well, anything can be said. So therefore, the happy are those who do not decide at all. Those who do not write judgments are the happy judges. See, the lighter wind talk apart, that is the reason why the judicial branch is given a little more protection, because every day they run into trouble. And politicians also, those who are contesting elections also have the problem. Now, you can't please everybody. Everybody has a problem in the world. No member of the legislature, no minister, no prime minister, no chief minister can solve all the problems of human beings. But the only thing is, periodically they'll undergo the process of filtration. If you do it well, next election you win. If you don't do it well when you are in power, you may lose. Well, occasionally these principles also may get reversed. Even if you don't do well, you get elected, and those who do well don't get elected. These things happen. We have seen all those things in our lives. The point is, taking all these possibilities, a constitutional system is prepared, is handed over to our generations for our future. Now, what is the purpose of this constitution ultimately? If you look at the preamble of the constitution, it contains the declaration. What is the purpose that is sought to be achieved by the constitution? You can discern from the preamble of the constitution. This whole arrangement is not for fun or just making somebody a Supreme Court judge or a High Court judge or a minister. It is not that. It is all this arrangement meant for securing certain basic values for we the people. That's how the preamble starts with the word we the people give to ourselves. For what? To secure for ourselves justice, equality, and liberty. These are the three values which are sought to be secured by the Constitution. And each one of these provisions made following in the Constitution is meant to provide some or all of the three values to the society. Either they are meant for providing the liberty, some provisions are meant for providing. Once again, liberty and equality are interconnected things. Without equality, there is no liberty at all. Now, if with these high ideals which are mentioned in the preamble, the Constitution is made, what happened in the last 75 years? To what extent we, the people of India, have successfully secured for ourselves these core human values of liberty, equality, to what extent have we achieved? In the last 75 years, how did we work? Now, here comes the most distasteful part of my duty today. We haven't done very well, according to me. One fundamental, the whole trouble starts with this. We, on October 2nd, January 30th, we go garland Gandhi's statue and his portrait here, there, everywhere. He didn't preach us any great political philosophy like Karl Marx or Adam Smith or XYZ, anybody. He told us only one thing: speak truth. That's one thing which we never practice in this world, in this country. All of us know, every one of us sitting here, I'm sorry if I'm offensive, how much of money is spent in elections? What is the limit permissible under the law? Has it ever been complied with in this country right from 1950, after we got rid of the colonial past, the white man supremacy? To what extent have we implemented that? I don't think. Well, a few years back, when I was still in office in Delhi, there was an occasion. There's a place called the Constitution Club in Delhi. Some event was organized there. Some 80, 90 of us. All the 80, 90 participants were people who were either holding as on that day or had held sometime prior to that some very high public office in this country. Senior bureaucrats, some retired judges, some sitting judges, few politicians, discussing various things. A former Chief Election Commissioner of India, one Mr. Brahma, around 2014-15, he was the Chief Election Commissioner. Incidentally, he's from Northeast and he belonged to the cadre of the old Andhra Pradesh. He worked in Hyderabad. I knew him personally. He was, by the time of this meeting, Brahma had demitted office. He was also there. He said the situation is very alarming. This was in 2015, perhaps. But after 2015, 2 elections took place in this country. 2015, he said, he made a statement, mind you, these are not my words. I'm not disowning it. I'm telling you, narrating an incident. Situation is very bad in this country. People are spending 40, 50 crores to become members of the parliament. Everybody in the gathering smiled. Nobody thought it's a serious matter not to smile. It's too serious a statement he made. The law doesn't permit that kind of expenditure. Why? Not because somebody made law, because there's a logic behind it. People must vote voluntarily, recognizing what is good for them, what is not on the basis of the 2,000 or 3,000 paid on the day of the election or one day before that. That is the purpose behind the law, which says this is a corrupt practice, it is procuring votes. We don't follow it. We never followed it in this country. Maybe other democracies also, some kind of monetary corruption is there, but not this kind of. Anyway, it may vary from place to place. I don't want to make a generalities. Let us confine ourselves with the Indian problem. And after that, if somebody is spending 50 crores to become a member of parliament, or 20 crores or 30 crores to become a member of the state legislative assembly, no, as I told you about the litigant who is a nice man or nice woman, if the politician is also a nice man or nice woman, he or she will at least recover that much of money for spending it in the next election. If the person is not such a nice person, he'll amass more and build estates. That's a different matter. Forget it. This is the default. Minimum, you must collect that much of money for the next election. And how do you expect in a system like this a constitutional governance as envisaged. All of us lose no time claiming that Baba Sahib was a great man who gave, but we have simply failed him. If he is such a great man and he gave us such a wonderful document, I have no doubt about it. He was a great mind. It's a very great mind. And how is it that we amended it 130 times so far? It is such a wonderful document because it doesn't suit our convenience. Every time something came in our way, we amend the constitution and go on the December 14th and pay salute to Baba Sahib. And they think we have done our job. Or do it on October 2nd to Mahatma Gandhi. See, that's the problem of India. Last 70 years, this continued like this. Take one more thing. There is a 10th schedule business. Till 1984 or 85, I think the 10th schedule was introduced during the period of Rajiv Gandhi. Floor crossing was a very favorite pastime of quite a few politicians in this country. I don't know, youngsters, we would have heard it or not. When we were college going, this kind of people, floor crossing, MLAs and MPs, there was a catchword, those days, Ayarams and Gayarams. They came in the morning, went in the evening from this party office. Obviously, you heard it, you are smiling. This is Ayaram Gayaram business. Parliament, in its collective wisdom, believed that this must be stopped. Therefore, 10th schedule was incorporated, saying this kind of a unprincipled defection from one party to another party should be stopped. 10th schedule was incorporated. In fact, I was collecting, unfortunately, I couldn't collect immediately because of my other commitments. In the last 30 years of the existence of the 10th schedule, hundreds of complaints, more than 100 complaints were received from various parts of the country in different legislative assemblies and in the parliament. And, whether there was in fact a defection or not, the decision-making process under the Constitution is entrusted to the legislative body, parliament or legislative assembly, as the case may be. How wisely or unwisely those decisions were taken, I will not go into in those cases where they are decided. But I have known number of cases, if exact percentage I may not be able to give correctly, at least 20, 30, 40% of cases, no decision is taken on the complaint. They are kept pending with the speaker. Speaker is the authority who is supposed to decide that. When that provision was challenged before the Supreme Court said the speaker is a high constitutional tribunal. Therefore, there is nothing wrong in the entrustment of the power to the speaker. We will not interfere with that. But then after that, in how many matters the matter remained? No decision is taken on that. All to suit political convenience of the parties from where people are, to which the people are going. That's human nature. So therefore, you need something to control it. The very idea of incorporating the 10th schedule in the Constitution, finally, did it serve any purpose? Is something at least the members of the legal fraternity may just think it over. In how many cases it was. I am not talking about where a decision is taken. The decision may be right or wrong. This is a different matter of opinion. We can discuss. But I am talking about only about those cases where no decision is taken once the complaint is lodged until the assembly is dissolved and the parliament is dissolved. No decision is taken. This is how we implement the con. And all of us, each one of us who hold or held a public office, take an oath that will uphold the Constitution as by law established. And eventually, when it comes to implementation, this is what happens. Now, this problem is nothing peculiar to India. It is a problem of human beings. Such things may not be in the same manner, in the same dimensions, or with the same intensity. May not happen, but this kind of problems exist all over the world wherever there are human beings. Talking about the judiciary. Well, it's no guarantee that the judiciary always reaches the right conclusion. But in the words of a very celebrated scholar on constitutional law, a gentleman called Lawrence Tribe, who teaches constitutional law in Harvard, he's also fairly old now, I think must be around 80 now, I'm told. He's not that well. He wrote a fantastic treatise on American Constitution. In the preface, he says, excuse me for a minute. Sorry. In the preface of that book, Tribe says, in the context of America and American Supreme Court, he said, I do not consider the judgments of the Supreme Court to be synonymous with constitutional truth. A court which held slaves to be non-persons, if you have completed your constitutional law study, but it can never be complete, the basic introduction. You remember the Dred Scott case of America, when a black sued for his declaration of his liberty, those were the days still some states abolished slavery, some states did not abolish slavery. This man by chance entered a state where slavery was abolished. He sued, saying that he must get a declaration that he is a free man since he is in a free territory. The matter went up to the American Supreme Court. It's a matter of historical record. The Supreme Court at that point of time said, all these rights guaranteed under the Constitution are only meant for the benefit of the whites and not colored people. It took almost about 100 years for the Supreme Court to get over that position and declare the position to be wrong judgment, Dred Scott. It was in this context, Tribe says, a court which held slaves to be non-persons. Separate is equal. Until Brown's judgment came 1954 or so in the Supreme Court, Brown versus Board of Education. Repeated, US maintained, all of us talk about India and the untouchability problem with which we know, we are familiar. Fortunately, South India is much, much better in that matter. We got rid of it much earlier. Parts of the country, it's still worse position. This discrimination existed in US also. It's supposed to be a great democracy for the last 200 years. Till 1954 in America, black children were not allowed to enter the schools where white children were studying. Black people were not allowed to go to the same beach where white people use. They were all separated. And it was questioned repeatedly, saying that this kind of an arrangement is constitutionally invalid as violative of the 14th Amendment of the Constitution of America. More than one occasion, the American Supreme Court justified such segregation with a queer logic. If black children are made to go to a separate school, don't mix with the white children. The logic adopted by the Supreme Court was, so long as it's the same curriculum in both the schools, so long as the same kind of table and chair provided to the student in black schools, so long as the same examination system is followed in both the things, there is no discrimination. But then making these children sit separately, telling them you can't sit with us, will have a devastating impact on the psyche of the child, is something which the American Supreme Court for a long time didn't recognize. Eventually, in Brown versus Board of Education, they said, no, it is in this context. Lawrence Tribe says, a court which held slaves to be non-persons and separate is equal, and gives one or two other things, could either hardly be final or infallible. Wonderful, all of us agree. But then the profundity of the scholarship of the man comes in the next sentence. But such passing finality as the judgments of the Supreme Court have is essentially a compromise between order and chaos. If we don't have an institution like that, if an institution like this, there is a possibility if it commits an error, it could be corrected a few years later. If the institution doesn't exist, you'll have to settle all these problems, taking a couple of sticks or modern days, take a couple of AK-47 weapons and settle these things on the road. Is it a society in which we would love to live? This kind of a society where things are decided by physical strength. I don't think it would be a very pleasant society. At least I am not willing to live in a society like that. Therefore, I always protested whenever I saw a problem that something is going wrong. Now, I think I have taken enough of your time. I don't know whether there was anything useful I spoke about. I can continue like this to point out various problems which this country went through, it's still going through in this country. In the working of the Constitution, I can I'll just give you one or two more examples. Lot of debate goes on every day about these very high-fly principles, and right now, for the last few days, something is going on. The Vice President of India said something, and then every TV channel is busy debating it, and wonderful ideas, opinions are coming out pro and against this thing. Let's not go into it. How does the system affect a poor man in this country? Whether the Supreme Court is great or the Parliament is great, just forget it. For a man who is driving an auto there, or for a man who is working for his daily bread, what matters more is if he has a small case, he is picked up by the policeman and taken to the magistrate, how long will it take for him to get the justice? After 10 years, if he gets a relief, what kind of a system is it? Is it what the Constitution of India promised us? Have we, each one of us, not you people, you are still at the threshold, but remember this, you will have to deal with it when you grow, when you enter the world. Therefore, I am telling you, have we done our best, my dear friends, of this time? Have we done our best to get the lofty principles mentioned in the preamble, translate them into reality within our own sphere, maybe as lawyers, as judges, or as politicians, whatever area where we had some role to play in the governance of this country? Have we done our best collectively? Individually, yes, they are excellent people. Some of them are very good. Some of them are not so good. Some of them are bad. They're always there in the world. But overall, did the common man get what the Constitution promised it? A man who had no access to power, a man who can never think of becoming a member of the Legislative Assembly or a High Court judge or a Supreme Court judge. Forget about it. A man who can never think of getting a government job in this country. Job at all, government or non-governmental job. What does this Constitution mean to him? They're all fine words, nothing more than that. Then why should he bother about it? But then, is it a matter to celebrate 75 years of the Constitution? Do we celebrate it? If it doesn't benefit anybody. Ultimately, we celebrate when we are happy. Why do you celebrate Pongal? Because you are happy. And you know what is the reason, my dear young friends? Why do we celebrate Pongal? Any idea? Some youngster? We're all urbanites, is it? It's a crop time. The agriculture produce comes home. So he's happy, therefore he's celebrating it. So therefore, when you're celebrating something, there is something really to celebrate. Here, 75 years is nothing. If I live a unhealthy life with all kind of illnesses in my body, I don't celebrate 75 years. I regret it that I lived so long with all these diseases. I do something. I go to a doctor, undergo a surgery, do something about it. So therefore, there's a time for introspection, 75 years. For that matter, every year, every day is a matter of introspection. For all my lawyer friends, I told you I'll not go into these high-fly questions. Ms. Ilangovan is a criminal lawyer. I mentioned this judgment not because it is great or I wrote it. It has all the elements of problem in this. One of my last but one I don't remember today, is a matter from Gujarat. 1989, in some remote town of Gujarat, there was a faction, nothing to do with religion or anything. Fortunately, nothing to do with religion. Some local factions, some political problems. There was a riot. 3 people died. On both the sides, number of people were injured. And my dear friends in the bar and judges know, injured witnesses have their own additional credibility in the matter of evidence. Injured witnesses were there. 3 people died. Case and counter case were registered. Normal rule is they must be tried together. It didn't happen. What happened to the counter case? There's nothing on the record before the Supreme Court. I recorded it. 17 people were accused. 2 people were found guilty of 302. And charges, an omnibus charge was framed before the Sessions Court. You 17 people, you are charged with offences 143, 142, 144, 147, 149, 307, 323, 326, 302. And at least all of us who practice in this part of the country, the old Madras tradition which was followed in Andhra Pradesh, charges are very categorically framed that you so-and-so, on so-and-so date, at so-and-so place, at so-and-so hour, attack so-and-so with a knife, or you know how it is framed. None of this kind. An omnibus one-line charge was framed against 17 people. There were 3 dead bodies. The post-mortem report of one of the dead bodies was not even exhibited in that case. There was no finding whether there was an unlawful assembly. 143, 149, everything was there in the narration. A finding whether there was an unlawful assembly or not was not there. And you know the requirements of unlawful. So not only the number, the requisite mental element. No finding is recorded. If there is an unlawful assembly, those who are members of the unlawful assembly are constructively liable under 149. That question couldn't be decided because there is no finding. 2 people were found guilty of 302. Interesting part is, guilty of what? I kill X, I am guilty of killing him 302 with an intention to kill him. There are 3 people, you simply say 302, guilty of killing whom? With reference to one person, there is not even a post-mortem report, whether it's natural death, unnatural death also is not on record. Still, the Sessions Court found these 2 people guilty of 302. Sorry to say this, the High Court confirmed this judgment. Matter came before the Supreme Court. This, in fact, I recorded in that judgment, every conceivable shortcoming in the administration of criminal justice system in this country is available in this judgment. It's a reported judgment, and if anybody wants to look, not because I wrote it, it's what is happening. Are we doing our best as members of the legal fraternity? We claim that we belong to a noble profession. We are supposed to be the protectors of the liberties of the people. And if we don't do our job well, with conscientiously, do a haphazard job, naturally people call us names, both judges and lawyers. See, public prosecutor, in a matter like this, I don't know who was the public prosecutor. He didn't even care to get the post-mortem report exhibited. And I don't know how the judges allowed all this to go on. This is what we have done with the Constitution for 75. But not that in every case it's happening. But one case is good enough or bad enough to demonstrate how... Now, we know everybody complains that the proceedings of court take generations. Naturally, with this kind of an efficiency level, it will take generations for resolving any dispute. Now, there are other problems. I know the insufficient infrastructure. Who knows, for good or bad, I had been the chief justice of two high courts. I know the problems. The sufficiency of the infrastructure is a major problem. In fact, on the lighter vein, I'll tell you, when I was in Kerala, there was some occasion. As chief justice, I was there on the podium. The then law minister, I think he is no more, Mr. Mani. I think he is no more. Mani, the deputy chief minister. Anyway, the inevitable dig at the end of the speech, the gentleman said, no, Chief Justice, but then courts are taking long time in this country. We must do something. So when my turn came, naturally I had to answer the charge. I told him, Mr. Mani, please check up your budget. What is your allocation to the judicial branch in this state? To the best of my information, at least I collected those days, in no state in this country, at any point of time in the last 70 years, the allocation in any budget did not exceed 2% of the budget to the judicial branch. The number of other offices increased. Take the statistical information. How many courts were there in 1950 in this country? Take Tamil Nadu, for example. And how many members were there in the bureaucracy in 1950 in Tamil Nadu? And take the statistics, current statistics in 2025, how many members are there in the bureaucracy? And how many courts are there in this thing? There's hardly any improvement. There's hardly any budgetary allocation. It is a legal system, perhaps for any administration, is a nuisance. We have to live with it. Since we can't abolish it, we allow it, but starve it. Don't allow it to improve. That's one problem. This is how the implementation of the system went on. Now, what are we celebrating today? No, I'm not saying that nothing happened in this country in the last 70 years. A lot of good things have happened. I'm not unaware of it. A lot of good things have happened. They happened not because of the Constitution, but in spite of the Constitution, they happened. We have better railways, we have more flights in this country, we have more better transports. In fact, the other day I was reading a report somewhere. In the state of Telangana, there are more number of mobile phones than number of people in the state. Somebody reported it. Well, there are certain good things happened in this country. I'm not saying that nothing happened in the last 75 years. But we take the stock. There is a need for improving it. There is a need for making a more efficient administration of the Constitution. That's all. I'm not trying to criticize individually anybody or something like that. But it's still not a very effective system we have established so far. System is good. In the implementation, we perhaps didn't meet the targets. Particularly, my young friend sitting on this side, our time is over. I'm on the last leg of my life. Future is yours. I only have a past. You'll become lawyers. Some of you may become judges. Some of you may become politicians. Some of you may become administrators. Please remember always this. This is meant for improving the lot of the people of this country. Forget about the people. Don't be so generous and think of your own safety, your own family, your own children. In a country where the legal system fails, legal system doesn't mean only court and lawyers. The whole structure, legal structure fails, none of us will be safe. Our children will not be safe, our grandchildren will not be safe. Keep that in mind. And an occasion like this, a memorial lecture for a young law student who untimely left this world, the tribute, if any, we can pay is to improve the system. Thank you.
Thank you, Lordship, for taking us throughout the journey of the Constitution, taking us from 1935 Act, Government of India Act 1935 to till date. And the system is good. It never fails, and we fail the system. That's a take-home message, and among all other systems. Now the floor is open, and of course, I request the students first, then the lawyers, then the judges. No, it's so not from a judge for put the question first. It's only the student to put the question first. Anybody, just start with the question. Yes, sir.
Okay. Warm greetings to, first of all, everyone and dignitaries.
Gentlemen, there's some difficulty in the acoustics. If you can kindly come closer, because, and second thing, remember, I'm 72, my hearing is a little...
Come on.
There's nothing wrong in being truthful about these things.
So,
Don't have to be ashamed. It happens with age. Tell me.
myself, Manish, I'm in third year in VIT School of Law. So, we were talking about accountability and transparency when we were giving speech. So, my question is related to RTI and right to privacy. So, in RTI, we read that there is a section which like RTI, we know that it's a very useful legislation which makes accountable for the government for the information. But again, it has some limitation. And if we see about the limitation, it's there in section 8, subsection 1, and clause J talks about that the government have to share the information, but they can deny sharing it. But when there is a larger public interest, they can share it. But again, we saw that new legislation came into picture, that DPDP Act 2023. In that section 44, subsection 3, in which it's giving an amending power, it's amending the section 8 of that RTI, which will now allow government to not share those information which is there, which can be there in the public domain, but they can choose not to share it. But again, this DPDP, a wonderful legislation, came into picture, but again, on the foundation of this Puttaswamy judgment. But now, using that legislation only, now if a situation is made where the government is not making accountable for its work, then how that the gray area can be solved? So that is the question.
Okay. See, it's all right, I think. For all these problems, whatever, anyway, I'm not trying to make a general answer for all the questions. But the kind of problem which you are promoting, the political awareness of the civil society is the answer. The civil society is politically aware, is willing to speak up on issues. The only political awareness in this country, we have, at least our generation, have witnessed all these years, is whenever we're unhappy, pelt a few stones at a bus or a train, and then we think we have discharged our responsibility. I'm audible? Yeah, but then there are various ways of registering your protest. But protest you must register in a more civilized way. If you remember Ambedkar's last day speech in the Constituent Assembly, give up this grammar of anarchy. Pelting stones and burning bus stations will not solve the problems. We must explore constitutional means of protesting. Apart from that, in fact, some 200 years back, almost 1830s, one of the greatest judges who ever sat on the American Supreme Court bench for a short period, he was there for 6 years or something like that, Joseph Story, wrote a fantastic commentary on the American Constitution 200 years by 1830s, he wrote. The concluding passage is the most profound thing. It's a long book running to some 800 pages. He says, he talks in the context of American Constitution, he said it, but it's valid for any constitutional structure. It reads something like this. The structure has been erected by architects of consummate skill and fidelity. Its foundations are solid, its compartments are beautiful as well as useful. Its arrangements are full of wisdom and order, and its defenses are impregnable from without. It has been reared for immortality. If the work of man may justly aspire to such a title, it may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers, the people. It's ultimately the people who can handle these things. No court, no parliament, no minister. Individually, none of them. It's ultimately the people who can. That's what was cautioned 200 years back, which is still valid even today. If something is going wrong, you must raise your voice and tell them. Mobilize people. Individually, see, one person shouting, man, nobody bothers. If 100 people shout, well, some effect will be. You remember some time back, Maharashtra, there was some problem with the onion farmers. They marched from Pune or Nagpur to Bombay. Some lakhs of people. Next day, the government came down on its knees. The point is, it's mobilizing people and generating the opinion, saying that this is. No, the constitutional remedy is going to the court, and whatever the court will decide, I don't know, depending on the particular question, something will happen there. I'm not on that. But the final, this thing, it depends on mobilizing and making people aware of their rights and the problems. That's the only.
Thank you, Nasir.
Okay. Hello, sir. I'm Karthik, a third-year law student from VIT School of Law. So my question is related to the the retrospection part you mentioned about the 75 years of Constitution. Like we need to.
I'll hold it for you.
Oh,
Then it's all right.
like we need to retrospect in the 75 years, right? I feel that the failure to socialize the constitutional principles like liberty, equality, and fraternity has widened the gap between the constitutional vision and the constitutional reality. So how do you think this socialization of these principles can take place? Do you think divisive factors like religion and caste are playing a role in obstructing this?
It's the old answer is, of course, one, when it may sound rhetorical, a famous statement of Disraeli, the former Prime Minister of England, some context said, above all, educate our masters, the people, educate the people, tell them this is right, this is not wrong. It's an effort. If you talk to 100 people, not 100 will agree with you immediately. You have to persuade them. That's the only. Nothing happens overnight in any country. What you think is a very mature democracy in America today, all kinds of things went on in the last 200 years. So therefore, 75 years is not that a long period for rectifying every problem. Effort will continue, will have to be continued. You need constant. And effort at individual level, that's why I said, future is yours. Each one of you. If individually we fail, collectively nothing can happen.
Good afternoon, Judge. I only have two questions to ask. One, only one allowed or two?
He is the master of the.
Thank you.
He is the master of the ceremony.
He is the model. I'm grateful for it. One, are we going to have a transparency in judges' appointments? Because often we've seen, I have practiced in England for 24 years, where they have a judicial appointment commission. They choose the judges with the lay members, judicial members, and other members. There are 16 members in the commission. They select. So there is a transparency. Who is going to be a judge? That will come out. Even for the president of the Supreme Court, he has to write 2,000 words essay to qualify to select his application in order to be selected. So that kind of test they are applying. Even in England, they are expecting the judge to write an essay, 2,000 words in English. So, but here, we do not know until now. It's one man and 40 others. They choose the judge, which he is going to protect the Constitution. We do not know yet. Like recently, the Supreme Court of United States, they say the Constitution, they go through the Senate, the Supreme Court judge gets selected. We do not have that kind of practice here. So will there be a transparency? If a man get appointed, easily he can be removed from the job. The Supreme Court says so. But when a judge been selected, we do not know. There is no transparency of judges' appointment in our country. That's a very sad state.
What is the question?
What's the
It's a
question?
comment you have
Will
made
we-
so far. What is the question?
Are we going to have transparency in future for judges
I'm not
appointment?
an astrologer to predict future. It
Very
requires
true.
an effort.
Very
If-
true.
If you want transparency, talk to Mr. Yanangovan. He is at the right place. Let him talk to talk in the parliament. Let them find out some procedure by which
Well,
transparency can.
Maybe the question is because your lordship was a dissenting party in the NAGC.
See, that dissenting judgment, I don't know, is quite frequently quoted nowadays. Whenever something goes wrong, people talk about Chelameswar said so and so. See, I never said hand over the power to the government. I said an alternative model is projected by constitutional amendment where 2 members of the civil society are going to be present. Otherwise, what is the allegation, which is largely true? That in the closed doors in the collegium meeting, what transpired, nobody knows outside. Why is it somebody is picked up at the age of 60 to become a judge? We have known cases. I don't want to name. Now, how is it that in other cases, 55 years and one day, no, cross 55 bar, he can't be cleared or she can't be cleared. And in some case, 60 yes. Why is it happening in the inside? So what is happening? At least the presence of 2 members of the civil society might act as a check on this kind of an activity. I'm not saying that all the judges who are members of the collegium are bad or good, but the system is such, it gives scope. Now, for my lawyer friends, you are a lawyer, you said.
Indeed.
You remember that Miraj Gar's case, 1964 Supreme Court. Just check up. There is a Supreme Court itself quoted a passage from Bentham, if I remember right. In the darkness of secrecy, all kinds of evil forces
True.
play. Anything, whether it's a political secrecy or judicial secrecy, secret societies are very dangerous things. So transparency is required. That's what I shouted at. Of course, the greatest lawyer of 20th century in India found fault with me for saying that. What do I do? What do I do? No, but point is, it's an effort you must continue. I didn't expect it the day I protested that I would achieve it that day. But I said, let this country know what is going on. Well, sometime maybe something will happen over a period of time.
My second question is.
Yes, sir.
We have 2 investigation agencies, one at the federal or union government, one at the state government. Often investigation, sometimes, very often, the federal agency go into the state officials, invest on the pretext of investigating something has happened. When the state has its own agencies, they can take up the action, they can prosecute, they can charge them, they can prosecute, they can convict. Those things can happen, is still happening. But federal agency intervening into the action and inaction of a state agency, that's a constitutional question. Because recently, a illicit Iraq incident, nearly 15-20 people died. Then immediately someone filed a writ petition saying that we want a CBI to investigate. When the state machinery already investigated, they charged them, prosecution is ongoing. Same kind, if any wrongdoing that can be done, that can be rectified by the state government. Why this federal agency with no notice go and on the basis pretext of investigation, they detain them for more than 36 hours for no reason? So far, the federalism is concerned that there must be a separation. Oh, yes, indeed. The distinction and the correctness of federal and the state. So how do we distinguish it? So because they have their own roles to play.
Sorry, I didn't get your name.
Dr. D. Shanmughanathan.
Ms. Shanmughanathan, this is a topic which requires a very deep debate. I agree with you, it's a very serious matter. But unfortunately, the problem is not resolved. It requires a deep debate, and I can't give a one-line answer to this, but I can just mention something. The question what is the authority of the CBI to deal with all these matters was decided by division bench of the Guwahati High Court. Of course, after I left Guwahati, Justice Iqbal Ansari decided that question. He said CBI lacks any legal basis. In substance, that's what Justice Ansari wrote. Matter was promptly carried to the Supreme Court. It reached the Supreme Court while I was still in office. It's 7 years since I retired. Supreme Court still didn't find to hear the matter and decide. On the other hand, if you people remember, a few years back, that's after my retirement once again, and not that I'm only taking it as a referential point. There was some problem in West Bengal. CBI, there's some scandal, some Sahara scandal or something like that. The CBI wanted to investigate it because these things. CBI people went. The West Bengal government did not agree. In fact, the CBI officers who went from Delhi to Calcutta were physically roughed up. It all appears in newspapers. Then the matter went to the Supreme Court. Unfortunate. Sorry to say this, but then I know I'll have to take flag for making this statement. The Supreme Court, instead of deciding the question squarely, gave a free advice, sit at Darjeeling across the table and sort out. It doesn't require a Supreme Court judge to say that any nice gentleman in the village can give this solution. It doesn't require a qualified judge, Supreme Court or High Court judge to give this advice. But that's what happened. It is a serious matter, I agree. It requires a full-time debate. There are a lot of things to be discussed about it. Time is not sufficient. I could have discussed it, but time.
Lordship, she has a question about the Constituent Assembly debate and the present situation, please.
Sorry.
Constituent Assembly debate contradictions and the present situations. Yes.
Hello, sir. My name is Avantika.
No, just hold it now.
My name is Avantika. I'm a second-year law student at BIT School of Law. I wanted to incorporate two of the things that you mentioned in the speech about how if angels were to rule over men, then we wouldn't need laws at all. And how benefactors are what we should ideally be focusing on building a society. You mentioned about scientists and such. I wanted to take up the Constitutional Assembly debates on language. Even though there were advocates for incorporating multilingualism in elementary education, such was not incorporated, and a language which was fully deprived out of its originality, if originality itself could be considered as an abstract, was finalized to be a language of our country. And such is not in par with modernism, because until the 2005 NCERT syllabus came into play, multilingualism was not as such practiced in our modern society. And even though there were people who were shouting for multi-language policies to be incorporated into our Indian legal and educational system, why was it not incorporated fully, even though we were...
Ma'am, young lady, why was it not incorporated? I have no answer. You must only ask those who are responsible for incorporating. I can't answer that question. Why didn't they not do?
No, sir. I wanted to ask, how can we deal with such contradictions when we are able to take up a Western idea of fundamental rights into our constitution? Why are we not ready to accept modernism and multilingual policies as such?
Multilingual policy means what according to your definition of multilingual policy? What is it?
It's about how we can use language as a tool to learn, as an utility more than a uniformity as such.
No, that's right. It's only through language we learn things, isn't it? We are
but
already
through
doing
all-
it.
And through all languages we can learn.
Yes, who's stopping you?
It's not about stopping us. It's about what we learn from our constitution makers.
Huh.
And they don't seem to advocate that we should be learning multiple languages. They are saying that one language should unite India. That should not be the case.
Madam, just as you have your opinion, they had their opinion, they expressed it. If you don't agree with that opinion, well, you promote your views, convince people that is not the right thing.
Yes.
That's all.
Thank you.
Thank you.
Only three more questions.
No problem.
Be specific on your question. Be specific.
Alagiri just got enrolled. Lordship. Is there any threat for constitution in near future?
What do you mean by a threat to the constitution? Please, no, be serious. You're a law student. Be precise in what do you mean by a threat to constitution?
Change.
Any change?
The change is constant. I told you, in the last 75 years, 130 amendments were made. Change is inevitable. But whether the 130 amendments were really required or not is a different question. They are debatable issues. I am not into it. But every amendment is not danger to the constitution necessarily.
Maybe I can help is maybe he's thinking about the entire constitution going to be changed today.
Abrogated. Well, uh, I don't see it immediately. Well, if I'm proved wrong, I'll be sad. That's all. So there'll be some amount of tinkering. It always went on. Last 75 years, it went on. From the first year, the amendment started.
Ultimately, these people will.
I told you, no, ultimately it's for the people. That's why I read that last passage of Joseph's story. It's for you people to protect the constitution. You means you, me, everybody. Forget about my past employment. I'm a citizen today. You are a citizen. It's for us to protect. If we believe this constitution must be protected and preserved, let us make effort for that.
So let us protect the constitution. Thank you. Next. He wants again about the NJC and the collegium system, but he has a different question.
Honor to meet you, sir. My name is Pranith. I'm a second-year law student at VIT Chennai. So my question is in relevance to appointments of chief justices. So in your case, Justice Mishra and you were both inducted into the Supreme Court on the same day. And given your experience as a chief justice of a high court, do you think the process of appointing chief justices was not fully used or utilized in your case? Sir?
No, I don't want to say. I don't want to plead my case today.
Thank you.
Sorry about your lordship. I thought he is going
to. You are entitled to ask the question, but I have difficulty in answering the question because ultimately all kinds of accusations. Oh, no, he is trying to still.
And your lordship is entitled to. Your lordship is also entitled to reject the question also.
Thank you, sir.
Warm greetings. I'm Vishaka, third-year law student. My question is with respect to since the delimitation discussion that's happening for implementing it in 2026 for increasing the number of members in the parliament, can we not expect an increase in the number of judges in the bench? Because the court only functions for approximately 200 days, excluding the vacation time. Not to sound funny, but can we not expect two Supreme Courts with regard to the existing pendency of cases persisting in the country?
Okay, you take the point. See, the problem of pendency can't be solved by mere increase in the number of Supreme Court judges. See, large number. See, Supreme Court, I think the pendency is some 60,000-70,000 cases. 60 or 70 right now, latest figure I don't remember. By the time I retired, it was some 55,000. Now it's something like that. Large number of cases are pending at the lower levels in this country. Your magistrates and your senior civil judges, district judges. Question is, increasing the number of judges is one thing, but what kind of judges are recruiting? If you get 5,000 judges, without meaning any disrespect to anybody, who are semi-literate or illiterate in law, what will happen? Point is one thing. It doesn't only depend on judges. It depends on lawyers, legal profession. What kind of assistance is being rendered by the legal profession to the court? You have an excellent judge, Krishna Iyer. Let us say, take some name, because there didn't got no controversy about him. Living judges can be controversial. And you go and, not you, me, I go and argue some rubbish before him. What can he do? So it's an overall efficiency of the system, the lawyers, the judges, supporting staff. We have a wonderful lawyer, Nani Palkhiwala, arguing before Krishna Iyer. Krishna Iyer doesn't know typing. He has a bad stenographer. Finish, it will take 2 months to deliver the judgment. He'll keep on correcting the drafts, particularly with Krishna Iyer's English. The stenographer will find it very difficult to translate it to typing. So therefore, when talking about efficiency, it just doesn't depend upon the number of judges alone. The number of other files. And it varies from institution to Supreme Court. Problems are something. High Court level, problems are something. Subordinate court levels, the problems are different. It requires a comprehensive analysis. Examination. Nobody has time for that. Nobody is doing it. Everybody talks about, no, courts are taking time. Or somebody says government is not giving money, therefore we are not able to. See, these one-line answers will not solve. Comprehensive debate and a concrete decision is required.
Thank you, Roshan. Thank you. We have a question from the judges side also. the
Good
bench.
morning, sir. I will come up, sir. I'd like to join you. I am a proud recipient of an award at your hands at Loyola. And before I raise
the
my
old Loyola
question-
students.
Before I raise a question, I would like to remind the audience of something which Elongo said. He was quoting you, but it went unnoticed for the larger part. He said that you informed him yesterday that the judges must keep their eyes closed and uphold the law. And that is what is much required today. That missed attention, I thought I should draw attention to that again. And
have a-
now,
we have a
also,
question.
and my question would be, there's much worry about the union government impinging on the powers of the states. To what extent would Article 254, which deals with repugnancy between union laws and state laws, and subclause 2 thereof providing for the state law prevailing despite the union law when they ascend to the president's seat, to what extent can we use that?
See, this is a technical question in the sense there are two laws, one made by the parliament and one made by the state legislature. And if there is some repugnance between both the laws, then 254 comes into play. What should happen is described there. Now, if the matter is reserved for the president's assent, there is some conflict. Still, the state law can be saved under 254, provided the president gives his assent. No, the president doesn't want to give the assent. What do we do? No, that is a raging controversy right now.
That is what I thought.
That's the raging controversy right now. Let us see what the Supreme Court decides. You want my opinion as a citizen?
Yes.
Well, if the president, ultimately remember, president in the context of the Indian Constitution acts on the aid and advice of the Union Cabinet. So it is a view of the, so though apart from the language, I didn't see the full judgment. If the Supreme Court judgment had said, we direct the government of India to tender the appropriate advice within 3 months, it wouldn't have been objectionable, I suppose. From what the vice president was saying, how can they, whether the president could be directed or not, I don't want to make this podium this thing. But Supreme Court could have simply said the government of India should take a decision because it's your advice on which the president acts. That would suffice.
If I may add there, I was informed that the worry of the states was that if such a direction is given, the governor will say, I'm above you, you can't direct me to do. The governor would say that. He will say under Article 301, I am not subject to yours.
Sir, these are all questions, political. There are no legal answers to this. If I say I am right and I don't agree with you at all, I don't accept the constitutional system. Sir, we have accepted in this country, we have borrowed it from various other countries, that the judiciary has the authority to decide whether a legislation is consistent with the Constitution or not. If I and you as judges of the court can declare a law made by the parliament to be unconstitutional, to believe that they have no power to direct a public office holder to do a particular act, to my mind would be constitutionally doubtful. At least I will not subscribe to that theory. I will not subscribe.
Thank you so much. Thank you.
One more question from the sitting judge.
With power to punish for contempt.
Sir, whether the journey is going the right direction?
Whose journey?
The journey of the Constitution. The journey of the Constitution.
Sir, that you remember my last quote from Tribe. It's essentially a compromise. It's a long march. There's no solution overnight. Overnight. Whether journey is proceeding in the right direction, it's an interaction of political forces in the democratic society. That's all. What direction it is going to take, how good it is, it's a value judgment. You may think it is not right, I may think it is right, or I may think it is not right, and you may think it is, but these are all value judgments. What is the point in making a generalized statement about it? They can do.
Thank you, Your Lordship. Thank you. Given a good applause for His Lordship's answers and Lordship, can you please?
5 minutes. We will discuss some
We have
prizes
one
also.
program. You know, the Rakesh Foundation is. We have one small program that we are appreciating the efforts of those students who are all helping. The Rakesh Foundation has been helping, and we'll call by the name, and Mr. Ilango and Aruna Ilango, and both of them will felicitate them with.
They are from the corporation school which has been adopted by.
The students are from the corporation school, and the Rakesh Foundation has adopted them, and they have given all the facilities, and they are the winners of this. I called by name. Dilip Babu. He has scored 584 marks in 12th standard. Aggregate marks, and the toppers. And Vindhya, she has scored 528 marks. And Patmavati, she has scored 507 marks in the aggregate. The next is Sakti Devi, 524 marks. They receive a cash rupees. Next is Siva. Give a good applause for him. He has scored 465 marks. He is from the corporation school. Next, I call Tarunya. She has scored 463 marks. Then I call Suman Raj. He has scored 422. Priyanka. Akash. Saravanan. Sandhya. And Gautam. Thank you. We thank the teachers, Mrs. Deepalakshmi. Mrs. Deepalakshmi, give a good applause, but they have brought out the students. And Miss Punita, Miss Behala, and Mr. Yuvaraj. We thank you all. We thank the teachers for this. And now we go to the last part of it. I request. What of thanks?
On behalf of the Rakesh Law Foundation, I extend my profound gratitude to the Honorable Mr. Jasti Chelameswar for graciously accepting our invitation and delivering an illuminating lecture on a topic of paramount importance to our nation. Sir, your insights today have
not only enriched the legal fraternity, but have also helped those who of us outside the profession gain a deeper understanding of our constitutional fundamentals. I must express a special appreciation to Justice Mr. Akbar Ali, who taught a cherished family member of the foundation through his association with my uncle Ilango. Deserves a specific recognition for his masterful moderation of today's session. Thank you, sir. And a sincere thanks to A sincere thanks to Roja Mutea Research Library, a cornerstone of the Rakesh Law Foundation, with a gratitude to Mr. Sundar for his unwavering support. The Hindu Mr. N. Ravi deserves our special gratitude for their consistent encouragement of the Foundation lecture series. Your support has been instrumental to our mission. Thank you, sir. I thank the DMK legal wing, law officers, advocates, members of the public who took part in today's event. I would be remiss not to acknowledge the media representatives, the auditorium management, the technical staff, handling and sound, those who arrange for the food and transportations. And I would also like to thank for attending the lectures by your presence, Honorable Mr. Minister Shekhar Babu sir, and students and professors of VIT Law College, and Justice G.R. Swaminathan, then Justice B. Rajendran, and Justice Vasugi ma'am. So to everyone who contributed to making this event a success, by deepest appreciation, thank you.
Thank you all. We come to a conclusion and we will be proceeding for our lunch. We invite you, all of you, to have your lunch and go. It's not over. Please come and join us for the lunch. Thank you very much. We close this function. Thank you very much.